Hello, and welcome to our estate planning seminar video presented by MB+M. Thank you for watching, and if you have any questions regarding what is discussed in this video, please find the relevant contact details below. We hope you enjoy.
My name is Vince Gagliardi. I'm a director and also financial planner in the firm, and I'll just sort of host the night. So, as we know, probably it's great turnout. Estate planning is probably not the most exciting topic, so again, we'll have it as engaging as possible. Probably the question is, why did we have a seminar or presentation on estate planning? As far as financial planners and many in the industry can vouch for, when we see clients, many clients don't have a will, haven't thought about a will, or potentially obviously don't want to talk about death. So they often ignore it. It's part of our role is to be engaging professionals and have that highlighted to them, because many of our clients have had a situational change where either they've sold a business, they're probably going through a separation, or their children have gone through a separation, or their child might be having a drug dependency. So quite often that's where we play our role, is navigating through those complex situations. And more importantly, we often see clients who have come in when they might have had a parent pass away and they've died without a will. Then it becomes a bit of a nightmare from an administration perspective and probably paying us some unnecessary tax. So that's where we see our role. We're not solicitors or legal experts. Our role is to help and connect and engage with professionals that we got in the room. So that's the main reason. We hope to get something out of tonight, but mainly the awareness is probably to go and do something. We've done our job. Just to talk about Steve before his presentation. Steve is obviously a director of SMR Legal, local firm in Shepparton, extensive knowledge in commercial property and also employment law. Life experience having a very large family property. As a lecturer at Melbourne University Beacon campus, and also director of the Nearly Leadership Program. Steve has served on a number of local and state advisory boards and committees, and has a keen interest in the non-for-profit sector. He's currently a director of Shepparton Villages and chair of SAM. He's also a Shepparton CFA District Headquarter Brigade member. Is that still? Yeah. Okay. So welcome. Steve.
Right, thanks. It needs a little bit of updating anyway. That's what happens when you work in a busy legal practice and you don't get time to even look at your own website occasionally and find out what's going on. The first thing I was just going to reiterate was, number one, thank you for having me along tonight. Can everyone hear me up the back? Secondly, what Vince said is really important. I mean, you've taken the first step to come out tonight to, I guess, have a bit of an engagement about not only wills, but also the estate planning side, which really do tie in closely together. We have a lot of clients come to us, particularly probably more with farming enterprises more than anything else, where you see the need for succession planning, sometimes with businesses as well, but quite often they fall outside the actual estate sphere because that's sort of dealt with, before, mum and dad or whoever's running the business retire and then pass it on to whoever else, whether it's children or someone working inside the business. That's very common. So it's more with the farms and succession planning. We see a lot of people in it. And to that end, it really is important that people, and it doesn't happen overnight, this sort of process where people look at their assets, and I'll talk about that in a moment for a little bit, where you actually look at all your assets and you take a global picture of, well, what have you got? What do you need? Because, especially say with a farm, and I'm going to use that as a good example, people are very emotionally attached to it all. And by the same token, you want to try and ensure that that survives down the road. But the other side of that is that you actually need to have enough for your own. You might live another 20, 30 years. I mean, we all say, the lifespan of people used to be sort of 70s was the late 70s was the average age. Now we're looking up to the 90s, 100s. And so, you've got to take that all into account with not only the estate planning, but also with the financial side of things too, which I'm sure Greg will touch on. So the window is not very small anymore. It's quite a large window. we all seem to still want to retire at about 50, 60, 70. I don't know how long I'll be going for, but anyway. But that's sort of the time frame of people. And so it's trying to work in those windows. And the other thing I'd probably say is a couple of just global observations is that, I mean, because you do something on that day and set in train what you think your plans are for the future, everything changes, as you know, in life. And so one of the things with estate planning is always to revisit it. And I know that's probably good for lawyers and accountants because it means more work for us. But I mean, just because you do it once and you think it's done, doesn't mean to say things change. And probably the most obvious example we see is where, for whatever reason, there might be an end of a relationship, whether it's a breakdown of marriage or one of the partners dies. And the will in particular has never changed. Well, if parties do actually divorce, the will is no longer valid. So there's an issue in itself there in the sense that if you don't have another will, you're going to die without a will. And I'll talk about that in a minute. But more importantly, where, and we see this so much where people actually re-partner, and maybe it's a generational thing. I don't know what the next generation will be like, but we see commonly coming through the door where people, for whatever reason, whether they're maybe a little bit shy, they don't want to discuss it with their blood relatives because, you know, typically if they're re-partnered with someone else, they're going to have their own children. And so it makes it a very complex scenario. And people say, oh, you know, life's simple and wills are simple. And it's very rare we get people walking in the door that, you know, they say, oh, my life's, you know, pretty simple and the will's pretty simple. And by the time they walk out, they go, oh, yeah, there's a fair bit involved in this. And so I just wanted to, so I'll talk about that a little bit, but just briefly, everyone probably knows what a will is. It's just a legal document, and there's a whole lot of form that goes to how you do it. There's a Wills Act that prescribes how you're meant to do a will. I noticed you had notepads. You could probably write your own will here and get 2 people to witness it before you walk out tonight, and off you go. But anyway, that's probably a bit too simple for most of us has, as I said, more complex lives than that. And then there's an Administration and Probate Act, which kicks in after someone dies and regulates how the executors look after the will and how they administer the estate, and also deals with, and I'll talk about that in a minute too, family provision claims, where quite often, for whatever reason in the will, people have either forgotten to include someone, have intentionally left someone out, and that person has a need. And so quite often you see people challenging wills as well. So nothing, it's not a perfect world. Our job as lawyers is to try and make it as perfect as we can. But we always say to clients, there's never any guarantees with anything. All you can do is build the best case. Simple answer probably is actually, if you can afford it or do it, is to actually not have any assets when you die. So if you divest yourself of the assets, before you go, then the family will be happy days. But it doesn't, because you know the saying, where there's a will, there's a relative. But anyway, go there. So just quickly, if you do die without a will, there are laws of intestacy that kick in. And I'm just going to quickly, just without going into great detail, because I don't want this to be a bit of a law lecture. It's probably more, I'd rather have questions than people ask. So we might delve into a few particular areas. But obviously, if you leave a partner, they'll get everything. If you leave a partner and children that you had, then that's fine. But then once you start getting children from a blended family, there's a formula where the first nearly $500,000 goes to the surviving partner. And then it starts getting split between kids, gets all a bit complicated. But there is a formula if you do die without a will. But that's fine if you just had some money. But ultimately, if you've got a whole lot of other assets and you have particular wishes, and this is where we would say to people, you know, what are the reasons for having a will? And I'll just run through a few dot points, because, you know, you need to have control over the assets that you have. There's no, and I think it was mentioned by Vince, you know, have you actually done the most tax effective thing with your assets as well? Because dying without planning for it means that you're probably going to, you know, that in Canberra, everyone will be happy because the maximum tax rate's more likely and not will apply. Also, if you've got children, you know, you've left children behind maybe without having given some thought to who you want to look after those kids. And I see we've got a mixed range of people here in ages. Obviously, if your children are old enough, post 18, it doesn't matter. But in a will where you've got young children, you obviously need to make provision, think about who you might want, someone who you trust to be a guardian for the children. And then, you may set up some specific sort of trust in the will as well for the children to, specifically look after them when they're younger, whether it's for education, accommodation, all those sort of needs. And obviously, whoever's looking after the will, the executor, also needs to be someone who you can rely on. So a lot of people sort of think, oh, I'll choose my best friend and all that sort of thing. But you actually, and a lot of people, I don't know how many times I hear it when people come in and there is actually work to do as an executor. Sometimes I don't think people who you've nominated as executor really wrap their head around the actual tasks that you're asking to do. It can be quite onerous. There is a thing called an executors commission where you can actually, if it's not in the will, you can apply to the court. And most parties, you say to them, well, look, you can go to court and the range is normally between about 3 and 5%, and the court will give it to you. And if you write to all the parties who are the beneficiaries to say, well, we will do this, if you don't agree now, they all turn it, they're pretty common sense and realise that, if there's work involved as an executor, that the executor does deserve some sort of commission, but you can do that in your will. Also, if there is no executor and it goes intestate, it could actually be a more expensive exercise as well, because you've got to do a lot of chasing around. One of the things is, and that's our job, and also with the accountants, is actually when people come in is collecting all the information. So it's really clear identifying what assets people have, because people come in and say, oh, I've only got this and that, and you walk out and, there's superannuation, there'll be bank accounts. And one of the things, for example, with bank accounts, and we always say to people, and this is a particular reason, put as many assets, if you're going to give it to each other, make as many assets as you want to as joint assets, because if you do that, whether it's property or bank, then you actually don't need to deal with it in your will, because what happens when one person dies, the other person automatically gets it without a will. And that's something people don't understand a lot. It gets more complicated with blended families, because the two types of ownership are joint proprietors or joint owned assets, or the other one is tenants in common, where you have your own separate assets. And so obviously, if that person here dies, then you're going to need a will, because if you haven't given any direction what you want to do with your assets, you die intestate. So, that's probably the big distinction, is giving a bit of thought, even just down, like I said, to the joint bank accounts or something. Interestingly, I just want to give you a couple of statistics just for a bit of fun. 55% of Australians actually die without a will, which is interesting. Jimi Hendrix, Kurt Cobain, Prince and Amy Winehouse died without making a will. Heath Ledger's will neglected to include his infant daughter, you might recall. Peter Brock made 2 wills using a will kit, and both were found by the court to be invalid. And I mean, when people come in and say, well, the will's going to be expensive, I say, well, you can go down the newsagents around the road. Welcome to buy a $50 will kit, have a go yourself. But, more often than not, as I said, if you've got assets, that simple will kit's probably not going to cut it. There's a lot of people that do challenge wills. There was a study in 2015 that found that basically 74% of challenges against wills were successful. And particularly where there was a spouse or a partner who'd been left out, and I touched on that before, 100% of those claims were actually successful. So the courts are actually very mindful, and I'll talk about this for a little bit, of a couple of things. Number one, if you've left behind a partner, so it could be domestic relationship, gay, doesn't really matter, whatever type of relationship you've got. And a domestic relationship is one where you've actually just been sharing expenses. And it doesn't mean to say you sleep in the same bedroom, anything like that. If you've got some sort of relationship together, you are in a relationship under the law in Australia. And so what happens, as I said before, particularly if you've repartnered, if you haven't actually dealt with that new partner in the will, then obviously they're going to say, well, hey, hang on. And particularly if there's kids who are left behind, who are adults and don't really have a need, which I'll talk about need in a minute, you will have actually left behind, it's called a disappointed beneficiary, because they're getting nothing. So quite rightly, they'll have a claim against the estate. And traditionally, over the years, people would have given maybe that partner a right to reside. It probably increased to a life interest, but in recent years, the courts have actually got a bit harder in saying, well, if you've left behind a long-term partner, spouse, whatever, and you've made no provision in their will for them or very little, the courts will actually almost overturn the will because they say that you've got a moral duty to look after those that are closest to you. And the second part of that test is having the moral duty, but also has that person got a need? So the big difference is between need and greed, as I always say. Greed being, well, it's just someone who's already got $1 million or $2 million and thinks that they, because they got nothing in the will, they deserve a bit more. Well, the courts probably will frown upon that. Although I have seen just recently dealing with a large estate where there was enough to go around for everyone. And so although we never went to court over it, a couple of the beneficiaries who already were quite wealthy and independent got 10% each. But the whole point is by the time you go to court, fight over it and spend hundreds of thousands of dollars, because actually going to this, you go to the Supreme Court to fight over the bigger estates. It's a very expensive process. What else? Okay, so that's talking about that. A couple of other things just to probably mention about wills, and I'm just trying to touch on everything pretty quickly here, is that there's also quite often we set up trusts, and our wills will always be set up on the basis of where you can elect or the beneficiary can elect to whether they have that trust or not, because you may not at the time, if they haven't done any financial planning or whatever, we give the option to actually elect whether you want to have a testamentary trust in place. And so what that does is then at the time of death of that person, it gives the beneficiary the option. And typically it's where you would be leaving them, say, around $500,000 or more in assets. It gives them the option whether they want to protect that in trust for tax purposes or whether they just want to take it and, go on a holiday somewhere or whatever they want to do with it. So we deal with that, but there's a couple of other ones you might have, and we see a lot of this too, where there are children for whatever reason, may have a disability or may have special needs, or you may have a child who actually likes to spend a lot of money very quickly. And so you can set up a protective trust under the will. Obviously, you've got to rely on whoever you appoint as the executor, who will normally be the trustee of that trust. You've probably talk to them, number one, and explain that you've got this situation and get them involved in at least being responsible. Obviously, you don't want to appoint someone who's 90 because they might die before you actually, you pass on. So you've got to give it a lot of thought about what you want to do, but you may set up a trust where you make it rather restrictive, where you might give, for example, a monthly income to one of your children because you feel as though that they need to be protected because they just, they'll go down to wherever it is and blow the money straight away. There is also an option of a special disability trust, which is a government trust, but it's for those people who actually do have fairly severe disabilities. And what it does, it has a tax incentive where if you contribute up to $500,000 into it, it actually doesn't affect the pension of the person who created the trust on behalf of the child. So there are some tax incentives there. You're probably going to talk about that one, are you?
No.
Good. Oh, that's all right. We haven't seen each other's notes, so I'm a bit wary of treading.
How long does it last for? The one you said about you can give them a monthly.
Well, you can do it until the day they die.
Oh, right.
Yeah, if you've got enough money. But yeah, you can set it up for however you like. I mean, it's basically any sort of trust, you can put it into whatever conditions you like. I mean, you probably got to be a bit sensible about it, but you can make it however you want to do it. Ultimately, if they're the sole beneficiary of the trust, they could probably, if they had enough capacity, challenge it and say, well, I just want to take it all. But most people are pretty respectful of the reason why the trust was set up. We do occasionally see where, the child might be on it for 10 years and they go, look, I want the rest of this money. And so you actually, they can wind up the trust and they're the sole beneficiary. That is one downside, but at least you've tried to set something up to get them going. Other issues to talk about was I've spoken about the moral obligation, where also, what else I'm just looking at? Oh, yes. Separation and divorce, as I said, if you do separate or divorce, the will you did have is automatically invalid. So you do need to do another will, or you should do another will. And also sometimes we do, if there's a particular reason why you've done something, sometimes people actually do statutory declarations where they set out the reasons for why they've done something. And look, it's not, as I said, nothing works 100%, but it gives some indication as to why you want to go down the path you have with your assets for that child or whoever you're giving the money to. And so if it's ever contested, at least that statutory declaration would have some validity. It doesn't mean to say to, guarantee that something can't change from that, but it does help with it. What else? I'm just looking through some notes here. I'll read a couple of other things because I know Greg's going to probably talk about that is superannuation nominations. Part of the whole estate planning, because a lot of people's superannuation as time goes on, it is becoming a bigger nest egg. And so trying to work out, well, are you actually, because you can take the superannuation out of the will by just doing an irrevocable nomination and be done with it. And that way it goes outside the estate. But sometimes that may not be the best planning for some particular reason. And maybe the superannuation needs to still come into the will. There's a whole lot of reasons and I haven't got time to go through them all and, so many different scenarios. But one of those things is to actually, when clients come in, we check with them. Well, they'll say, I've done a nomination. We say, well, can you get it for us to have a look at? Because more often than not, it might have just been a nomination. And unless it's irrevocable, they actually lapse after a couple of years, those nominations. So unless you've done an irrevocable one, it means that it will lapse anyway. And so the money will come into the estate. So it's just getting everyone to turn their minds to all the assets, what you're doing with each particular asset. Other thing is, what else? I think that's about it.
Steve, do you want to touch on the power of attorney?
Oh yeah, power of attorney. Yes, I got so excited on wills. I do. Just so you know, with our estate, that's why I get excited about it, because I do all the estate disputes. I don't actually draft the wills very often. We've got another lawyer in the packs here. We've got a large estate wills and estate team. Marie Leschke, who's our lawyer there, she drafts all the wills. Nina O'Brien does a fair few of them, but I just like doing the disputes. I sort of like the complexity that comes with it and all the family love. Look, it's a good thing because, I mean, at least I think one of the things is as you're a bit more mature in life, you can, and I've come from a farm, so I can look at people in the eye and say, well, no, you're just being an idiot here, move on, or actually something you're telling me makes sense. And I think that's the sort of frank advice you've got to give to people sometimes, instead of, you can be too much of a lawyer without being really trying to understand you're dealing with people and you're dealing with a family and you're dealing with human beings. And that's always sometimes a bit of a complexity and a layer that you should add to the advice you're giving. Anyway, powers of attorney. The other main thing is, and I did touch on it earlier, we're all living longer. Maybe not necessarily better. That used to be a government thing, wasn't it? Living longer, living better. And so when we don't live better and we lose our marbles, as I'd say, one of the things that I say to people is that that's much more common, as you know now, the prevalence of dementia, all those sort of illnesses that afflict us as we mature a bit in life. If you can have the time, because it's actually not a very expensive thing to do, to actually create powers of attorney. There's one document deals with financial and personal affairs, or it used to be the old guardianship. And the other document is medical treatment decision-making. So if you can turn your mind to those documents and actually do them, I think you're doing your whole family a favour, because although it's a fairly relatively cheap process, it can be traumatic. You've got to go to VCAT if you need to get administration and guardianship orders. If someone has, lost their marbles, pardon the expression, but that's essentially what it is. They don't have capacity anymore. And so it's, if at least you've done that to yourself, you've started thinking about some of the things you need to do. You can appoint joint or several people to act as your attorney on your behalf. You need to find someone who you trust. Kids aren't always probably the best option, because you'll hear it time and time again of kids doing elder abuse with finances and everything. I haven't got time to talk about that tonight, but it's real and it happens a lot. So you need to think about who you actually appoint. It can be joint and several. Now, I always say to people, probably having it joint and several, so joint means you need them all to agree, is in this day and age is a bit more difficult, because people live everywhere. Getting hold of them on every single decision may not actually work. If you can trust each of the people who you appoint, then you should do it severally as well, which means that one of them can do it on behalf of the other. And of course, they've got a responsibility to let the others know what they're up to anyway. So, you know, it just doesn't mean because you've appointed 3 people, one can go off, do it all and not let the other 2 know what you're up to. So you've got it's a very important document. The guardianship side obviously deals with where you're nearly done, where you might nearly live. And the last one is the medical treatment decision. And I just wanted to say with that, look, I jokingly say, you know, you can make your decisions about what you want in your dying moments down to, you know, whether you want a nice Volvo or something like that. But it is, you know, people actually should think about and should let others know in the family what, you know, whether you do want to have, you know, heroic medical treatment, whether you want to be resuscitated. I mean, they're awkward conversations, but they're very real. And I don't know how many times I've seen, you know, children who are in total despair because they don't know what their parents wanted. You got the doctors, typically, they're getting better, used to just be so heroic and say, well, keep the person alive, keep going, but they are getting better at sort of saying, well, you know, maybe it's time to just go into palliative care and you know, go down that path. But, you know, they're awkward conversations sometimes, things we don't want to deal with. There is an advanced care directive that runs with that gives directives as well, which, you know, I spoke about the ISPO, all those sort of things. If you want to be very specific about certain scenarios in your life and your health, you can spell it out a bit more. But I'd at least recommend the powers of attorney. That's probably, how's that?
Question time?
I've got a question. If you don't have a power of attorney and you lose your marbles, what's the process for the kids?
You mentioned you go to VCAT, Victorian Civil and Administrative Tribunal. The fee's about, I think it's gone up again, about 100, it's near about $100. They've got an expedited list where it might still take about several weeks at least to be reached. It won't happen overnight. There's an on-form application. You've got to get a medical doctor to fill out about a 6-page form saying that that person doesn't have capacity. But part of the problem is, if quite often by the time people actually need to do something, the pressure's already on to have that document there, because you might want to get them into respite, nursing home, whatever it is. And if you haven't got that authority to do it, you know, those places now, everyone's, you know, follows the law by it to the letter T, will say, well, we can't do anything until you get that document. So even though sometimes you can be the next of kin, if you're the partner, you can probably, you know, wrangle your way around with some things, but, you know, you can't walk into a bank and operate a bank account or, you know, none of that stuff unless you've got a power of attorney. So Sally just asked, more and more people are giving money to their kids up front, and do we have any advice around that? Well, look, I'd probably say, number one, if you can afford to do that, I think that's actually a good thing in helping your kids. Is it right for them? I don't know. I'm not a parent, you know, of those children, so I can't make that judgment call. But if it feels good and you're seeing an outcome from it, then why not? Why wait until you're dead? Because you'll never get to see the benefit from it. The biggest downside of doing something like that is that obviously, if you're giving assets away, they then will become subject to possibly a breakdown in a marriage with one of the kids. So once you've divested yourself of that asset, it then obviously, if that child that you've given it to has a partner and there's a breakdown of a marriage or a relationship, doesn't have to be a marriage anymore, just that relationship, then obviously it will become, it's an asset that the Family Law Act will look at. And you can't escape the Family Law Act, whether it's trust, whatever, you know, ultimately, you know, the Family Law Act basically puts its tentacles on everything. Anyway.
So where you got one child that you give some money to, and you don't to the other.
Yep.
Document into the will.
Yes. So yeah, if you give one, so yeah, if you give it's
an equal share.
Yeah, unequal share or whatever, and you want to top it up in the will, you just record that in the will or whatever. So you can do all those sort of things. Yeah. And obviously we would say, well, you know, also document, you know, the bank statement where you transmit the money as well, and we'd keep that in our deeds. So the record's there to prove that it actually happened. You know, quite often parents loan money to kids. I don't know how many of you done that. Put your hands up. I reckon, but come on, yeah, be honest. Yeah, anyway. And so did you do it in writing? No. But
if you do it in writing and you get them to sign it, yeah, so it's not through the solicitor, is that legally binding then?
Most like it will be, yeah. If they've acknowledged the loan and if you attach the bank statement as well, showing that you gave them the, the money, that it's proof of something happening. Because down the road, what happens as time goes on, you'll say it's a loan, they'll say it was a gift. And I tell you which one typically ends up, being the right answer. If you're no longer here, and you've got the poor old executor saying, well, they told me it was a loan, and then the kid's saying, no, look, it was a gift. Come on, what are you talking about?
If it was a separation and it's on paper.
Yes, definitely with that, you should be documenting that stuff, definitely, and probably putting a mortgage over an asset too, if you can, like if you're lending money to a house or something to protect that, like if it is genuine.
Yeah.
Someone's gifted money through a will,
Yep.
whether it be or money or property. Who's liable for the tax?
Good question. So I did skip that, and Greg will probably touch on that. But one of the things, and this is probably the most interesting thing I've seen, is that I've seen in a lot of wills. I'm not going to name and I'm surprised that I've seen wills created by many lawyers from all over the place where they obviously didn't give advice to the clients at the time. Because if you actually, your money in superannuation, whether it goes into the estate or via a superannuation scheme, if it ends up going to a child who is not financially dependent, and that means more likely not someone who's over 18 years doing their own thing, if they're not financially dependent, they'll pay the top tax rate, which is 30%. Whereas if it was, if it's a financial dependent, so the spouse or the children who are minors typically, unless there's a need or something like that and they're being dependent, then, obviously the lower tax rate. So I've seen plenty of estates where, it might be $1 million in super come in and that goes $300,000 to Canberra straight away. And that's just what happens. It's actually 35%, isn't it, I think?
We'll cover that.
Yeah. There's a bit of variation, but it's roughly around there. So, that hurts. So that's going to be the intersect to Greg talking about doing some planning around things.
Depends on the asset.
Yeah.
How's an enduring power of attorney actually triggered?
Triggered.
So which state?
So Mike just asked a question. When is a power of attorney triggered? So you normally have, well, the medical one is quite clear. You can just do it when that person doesn't have capacity. And so that'll be an assessment by a doctor. With the financial and the guardian, you can appoint someone as your attorney straight away, which does happen a lot because if you're going overseas, traveling, can't be bothered doing all the finances and leave it with the kids. But I think more and more as time goes on, people are feeling a lot more confident doing things themselves because with technology now you can. So the norm now would be that it doesn't trigger until you lose. You indicate in the power of attorney, whether it triggers from the day you sign it or whether it commences on the day you no longer have capacity. And the simple way, you don't need to be very technical about it, is just obviously the doctor and the kids will they'll know straight away. And we tend to go to the medical profession because we've got to be careful ourselves. It's particularly if we're doing wills, for example, where people, I've seen it happen a lot, where kids bring their parents in saying, oh, mum and dad just need to redo this will. And you say, well, you've got to stay out here, talk to the parents, and you sort of go, And so I don't know how many meetings I've said, well, you need to go away and get a medical certificate for your mum or dad before we're actually going to take will instructions, because, it's too late. And then once the will's made, the will actually stays with the legal firm that makes it. And, it's amazing how many powers of attorney people actually contact and say, oh, can I have a look at mum or dad's will? And you go, no. You'd be amazed. Right? Because they want to do a bit of financial planning themselves, I think. Anyway.
Greg Luscombe. Many of you in the room know Greg. He's been a director and part of the firm for over 30 years. Greg's an experienced, straight-talking financial planner and business advisor whose focus is to ensure that you enjoy a sound financial future. Greg takes a holistic approach and extensive qualification both in financial planning and specialist taxation allows him to provide a rock-solid advice on both fronts. Greg is one of the first points of call at MB+M for specialist income tax matters, and this, linked with his financial planning expertise, provides a unique set of skill in our community. So, welcome, Greg.
Thanks, Vince. And thanks very much. My little section tonight is talking about death and super. Yeah, fantastic topic. Anyway, get straight into it. One of the first things I want to point out is that your super is not actually owned by you, which is a surprise to a lot of people. The deceased estate doesn't automatically deal with your super, which Steve did touch on, which I wanted just to explain why that is and what you can do about that. So basically the general rule is that the superannuation trustee, whether it's yourself, if you've got your own self-managed super fund, or it's someone you don't know through a bigger fund, they're the one that decides what happens to your super unless you've provided them with instructions, which again, Steve touched on that, which I just wanted to expand on what it is that you can do in terms of instructions that you can provide. Now, it does depend on the fund's rules as to what options you have and how you do that. So it's not a blanket one way of doing it. It does depend on your fund rules. There are some general guidelines that funds have to follow, but it will depend on your deed. So that's always the thing with superannuation, particularly self-managed super funds, is that you need to understand what's in your super fund deed. Basically got a number of options, just working through them. They're called death benefit nominations, as Steve alluded to. There's various options in general. A non-binding death benefit nomination. We don't see too many of those, but that's a statement that you make. It's a wish that's not binding on the trustee. So you're giving them a bit of an idea of who you want that money to go to, but ultimately they can choose not to follow that. It's only a sort of indication of what your wishes are. To give it more certainty, you then need to move on to what's called a binding death benefit nomination. And as again, Steve alluded to, you can have what's called lapsing or non-lapsing. Okay? Lapsing means that after a certain period of time, and typically it was around 3 years, and again, it depends on your deed and what the rules say, whatever nomination you might have made might have been binding for a period of time, but then ceases at an anniversary of a 3-year period. More and more we're seeing now non-lapsing variety, which means that the rules of the super fund have allowed the member, you, to make a nomination that doesn't lapse unless you change your mind and you make a new one, okay? These lapsing binding nominations, they automatically cease to operate at the end of that date. And you have to obviously make another one, which sometimes they can get forgotten. The non-lapsing variety will continue physically making. So those nominations all deal with lump sum superannuation. The fourth one deals with a pension scenario. Okay, a reversionary pension operates where, on death, the pension reverts to whoever you've nominated. Obviously, typically it will be a spouse, but that happens automatically. Again, it's like that binding death benefit nomination. If you've got a reversionary pension, it happens automatically. Okay. Excuse me. Questions are, what is best for you? That's not an answer. We're not going to give you that answer tonight. It's going to depend on your circumstances. But the key things are you need to understand what the rules are and what your options are, and then determining what is appropriate for you. It might be based on tax, or it might be based on family situation. Second question is, how do I make a nomination? Again, I'll go back to what's in the rules of the trustee will determine how you formally need to make that. But typically, they all have to be in writing. And if they're binding, they need to be witnessed by generally 2 independent witnesses. Unless you follow all of those rules, the statements that you've made are ineffective. Even though you might have thought you've done it, they will be found to be ineffective at a crucial time when you've passed away and you're looking to implement your wishes. Okay, so it's really important that they're done properly. You understand what's in them and you understand when they might lapse or not lapse. Okay. On to who can you nominate in those benefit nominations. There's a few aspects here. Question is, who can you nominate? Spouse. The rules include de facto partners, which Steve alluded to. It includes same sex, but it doesn't include former spouses. There's a distinction, which we'll come to in a minute in relation to spouses. It includes any child, adopted, stepchild, etc. It includes the estate, but it also includes a couple of other more less likely scenarios, but financial dependent. So it may not be a child, but someone who's financially dependent on you. And interdependency relationships, which is a further complicated scenario where there is a relationship and you rely on each other. May not be financial, but there may be other components to it. They also can be nominated. I'm not going to go into what constitutes those tonight. It's just a matter of, okay, they're the people you can nominate. Who you can't nominate is also important. Can't be a parent, brother and sister, or sister, cousin or friend. Okay, we've seen, particularly young people nominating their parents to be the beneficiary of their super. They may have done it, they may have filled out the right forms, they may have signed it, everything, but it's not effective because the super rules don't allow that.
What if your parent is financially dependent?
Yes, that's fine. So what Penny's asked is, what if your parent is financially dependent? Okay, you're here, you're excluded, but you're included back in here as a financial dependent. So that is relevant. These are just the general scenario, and pictorially we've set it out here where you've got super can go to your spouse, child, or the estate. It's probably the three main areas. Obviously, it also includes these. But the point that we make through the estate is that, as Steve alluded to, you can nominate anyone through your estate as to be a beneficiary. Perhaps didn't touch on the fact that you can also include charities and non-individuals, if you like. You can't do that through your super nomination. You can't nominate that your super goes to a particular charity. What you'd have to do is have it go to your estate, and then through your will, and you can distribute it out to whoever you wish. Next question is, well, why make a nomination? Okay, there's probably two significant reasons to consider a nomination. One deals with challenging estates. Steve alluded to that earlier about, a lot of his business is around disputes on wills, etc. A death benefit nomination done properly can't be challenged through the normal processes. Okay, so that's one of the benefits of making a nomination if it's binding. That death benefit payment, when it's paid, is not subject to the normal challenge rules. Okay, so you're keeping that out of the estate issues. Second main reason is it becomes your choice, not the trustee's choice. Okay, you might think, oh, well, the trustee will do the right thing and distribute it to my spouse or to my kids, but it might not be in the proportions that you want, or it might not be, who you want it to go to. So that's the other main reason for making the nomination, is you're taking control. You're looking for certainty and peace of mind as to what you want to do. There's a legal process which involves putting those nominations in place to allow that wish to be, as well as we can, put in place. Moving on to how super is death benefits and tax, which again is another complex area. Depends on who receives the payment and also what the tax components are of your superannuation. So there's a couple of main factors there. Who receives the payment depends on that dependent or non-dependent definition, which we'll look at in a minute. And what the tax components of your super are depends on whether it's tax-free or untaxed, which is a bit of jargon, but it does confuse everybody because the reference to tax-free is when we're talking about the component on death. It gets confused with the fact that once you're over 60 and you're still alive and you're taking money out, it's always tax-free. Okay? But on death, there's some tax components that will determine the tax to those beneficiaries. This is a bit of a summary of how that works. We've got the different components. We've got the tax dependents. So the dependents basically are those that you can nominate, except that the spouse, that should say not former, should have a cross on it. So it does include a former spouse can be a tax dependent. We've got child only to the extent that they're under 18 or under 25 and still financially dependent or have a disability. Okay, so if an adult child is on the other side, which is not a tax dependent, we'll come to that in a minute. Also, the financially dependent and interdependency relationship come into this tax dependent category. So there's a slight difference to the previous slide where we were just talking about dependent, which is a superannuation nomination dependent. The former spouse qualifies differently. Consequence, tax dependent, these people getting superannuation on death is always going to be zero tax, regardless of what the components are or the makeup of that payment is. It's the non-tax dependents that we end up paying some tax. 15% for those in the taxable category. And what's in taxable? Any contributions that you've made over your life that you've got some sort of tax benefit from, okay? Including what your employer is putting in, because you're getting that effectively taken out of your wage or effectively replacing your wage. So you're getting that as contributions. The CC is the technical term, concessional contribution, plus whatever it's earned over the lifetime of the super. When that comes out on death to a non-dependent, there's 15% tax plus Medicare levy. Okay. Component on the far right is untaxed, which is any insurance payment. So if you've got insurance in your super and there's a payout on death, that comes into that untaxed category. Or if it's a special government funded superannuation fund, they're both treated as untaxed. The tax rate on that money is 30% plus the Medicare levy. Okay. So really, this is probably the main scenario where you've got taxable component going to a non-tax dependent being an adult child. They're paying effectively a death tax, which is the 15% plus the Medicare levy. Okay.
Lie around that.
Yeah, how do we get that rid of this?
How do we minimize benefits? So yeah, there's a couple of sort of basic things, but start with this one at the bottom. Simplest thing, if you can arrange it, is to take all the money out before you die, which Steve alluded to earlier. When you take the money out, as I said, over 60, tax-free, eliminates that tax component issue. Okay. That's a bit hard to organise sometimes. You've got to know when you're going to die and you've got to be able to take all that money out from wherever it is. So while that's a strategy, might be a little bit hard to implement. The other main option is to what we call look at recontribution strategies. What that's doing is changing those tax component mixes, the mix, okay? If we go back to this slide here, if we take money out of effectively this category while we're alive, we pay no tax. And if we can put it back in as what's called non-concessional contributions, so we're not getting any tax benefit for putting it in, it then comes back into the super scheme as not taxable at all on death. Okay. Now, when you should do that and how you should do that is something you really need to get personal strategic financial advice, because it will depend on what you've got, how old you are, all those sorts of characteristics. So that's obviously where we come into play and help negotiate through the rules, apply them to yourselves, around what you can do, but that does change that tax component and can reduce quite significantly the amount that's in that taxable component and put it into the tax-free. One of the things that's happened more recently is the government have extended or pushed out the age at which you can make contributions. Okay, so there is always an age cutoff. That age limit has been boosted up, so it has opened the door for a lot more people to activate these sorts of strategies. Okay, so we are seeing quite a bit of that at the moment. The door might get closed, so need to be looking at it while we can. As you know, the rules are always changing. Fortunately, last night there wasn't too much that changed from a superannuation perspective that they hadn't already flagged. So none of this is affected. So we're still able to look at helping people reduce the potential death tax for their dependents by looking at those recontribution strategies. Any questions on any of that?
So that your contribution caps all bring into that, don't they?
That's right. Yeah. So the question is, there's obviously limits, contribution caps around what you can contribute. So in dealing with these contribution strategies, that's where that personal, we need to work out, well, what is your specific limit? Have you used some of it already, et cetera, et cetera. So that's why we obviously need to provide that personal advice. Question?
What about if it's an asset that you're willing, like, does that asset have to be sold to, like, if there's still tax owing on that asset, do you have to sell the house, sell the farm? How does that work?
In terms of the assets, we'll just break that up. You've got your superannuation. If you've got your own self-managed super fund, that might own assets, might be property, might be shares, etc. On death, the money generally has to come out of that super fund unless you've got an ongoing pension that can continue under that order of reversionary. So if you've got a two-member fund and one passes away and there's an automatic reversionary pension to the survivor, nothing actually has to change in terms of the assets. Everything stays the same. The pension just gets paid to the survivor. Okay. However, if there's money that needs to come out of the super fund, well, then yes, you would need to be potentially selling assets. Okay. And then the super fund will determine the amount of tax that's payable on that disposal. Again, not necessarily covering it tonight, but depends on what stage that super fund's at as to whether it's a 15% tax if it's still in an accumulation or, in accumulation, or zero if it's actually paying some pension. Or in a self-managed super fund, it could be a mix. So it gets a bit complicated, but that's the superannuation scenario. The other scenario is assets that are outside super, which is probably what Andrew was alluding to earlier around if we have to sell the property through the will, what happens? Who pays the tax? Okay. Well, the tax is payable. Well, it depends on whether the asset is passed on to the beneficiary through the will. So if the property is passed on, there's no disposal on death for tax purposes. The asset goes to the beneficiary, and the beneficiary will pay the tax when they sell it. Okay. But if the asset has to be sold to be able to get the cash to share it around, well, then the estate will need to work out what the tax is on that asset. Okay.
The tax.
Another good question. So the question is, how do we work out the capital gain on a property that's being sold, that's part of the estate? So it's not part of the super, but part of the estate. Then comes down to, well, when did the person who owned the property, who's passed away, when did they purchase it? Okay. If they purchased it before the 19th of September 1985, which is capital gains tax date, then there's no tax at the date of transfer, and you get a current value as your cost base for future sale. Probably less and less of those properties. So the other scenario is if the person who's died purchased it after that September 1985 date, that cost that they, the cost to them is your cost going forward. So when you come to sell it, if you're the beneficiary, you're effectively paying the tax based on the increase in value from the date that it was originally purchased.
vary between if you've got multiple sets and leaving it to
Absolutely, yeah.
be a difference to each child. So.
Correct, yes. So you might leave one property, they might be all worth the same to you. Think of sharing that equally across each of the kids, but they all might have different tax liabilities that are attached to those properties. So again, that's something that needs to be considered when putting the will together as to, you know, is that an issue for you? Is there a way of equalising that or working something out? Automatically, without any reference in the will, they might correct me if I'm wrong here, but it would be that whoever the beneficiary was would be bearing that tax without any sort of compensation. Square it up. You can put in the wills that there is an equalisation process, but unless it's in there, go and be taxed by the beneficiary and suffer the relevant tax.
The tax component mix, when you're taking money out of your super,
yep,
and you're in a pension phase and you're a certain age, are you still able to repay that into your super to get that mix?
When you take money out of super, well, the question is about the components and what happens around withdrawal and recontribution. So when you take any money out of super, you don't get to choose, I just want to take this bit or that bit. You've got to take it out in proportion, okay? So if you've got an account that's got 50% in tax-free and 50% in taxable, when you take that out, okay, that's what these components reduce by. You pay no tax on it, but always when you put the money back in as a non-concessional, it goes back in under tax-free.
My query actually is, are we allowed to put it back in at any time? Are there rules relating to when you can put it back, how much you can put it back?
Yes. Yes, there are rules around how much you can put in and when you can put it in, which is around the contribution cap amount. So there's a limit generally of around 110,000 per year per person as a non-concessional, and then you can bring forward 3 years in one, so you can get it up to 330,000. But again, that is where the personal advice comes into it, because you need to work out the rules. They get a little bit complicated depending on your age. And as I said, there's a cut-off point where you can't put money back in. Yeah.
Okay, thank you.
I was going to ask, early on in your presentation, you said you don't actually own the super or the money in the superannuation funds. Who owns those superannuation funds?
Yeah, good question. It was right at the start. It's not personally owned, it's owned by a trust. Okay, the superannuation fund is a trust. Okay, that's why there's a trustee who's looking after that money for you. Even your own self-managed super fund is the same structure. You're looking after your money for you. Okay, but it's not actually your personally owned asset that Steve was alluding to earlier about being able to deal with that through your will. That's why you've got to get the super money into your estate by leaving it to your legal personal representative or nominating your legal personal representative to get it into your estate and then deal with it through the will. So it's actually in a trust structure. Superannuation is trust structure, which probably sort of leads on to, you know, a number of you may have other trusts that are currently in existence, you know, family trusts, for example. Again, you don't personally own the assets that are held by that family trust. The trustee may be an individual or a company that's actually the owner of those assets on behalf of the beneficiaries, which may well include yourself. And again, it's a trust structure, which is another complication in terms of dealing with putting a will together as to how you pass those assets on, which is not something we necessarily covered today, but is something that is also adds to the complexity.
Can I add 30 seconds on it?
All right.
Larger superannuation companies merging,
yes,
by whatever means, we don't know who they are,
yes,
handling your money. They're getting together these mega billions and paying, you know, $3 million for their CEOs and things like that in their boards. And a lot of them aren't making money, they're losing money.
Question or there's a comment?
seem to be getting away with that type of thing. Is that something you should remove your super out of those companies into matrix?
Well, obviously you're going to be comfortable where your super money is, because it is your money, even though legally you don't own it directly, it's through this structure. You've got control of it, or you should consider that you've got control. Even if it's a fund that you don't directly manage yourself, you still can nominate where it is and where it's invested, etc. But if you want ultimate control over it, then maybe a self-managed super fund is your option. But all those options are things that we can sort of work through with people to work out what's the most appropriate. Some people are comfortable having it in those big industry funds, others are not. It's horses for courses. There's no right or wrong. It just depends on what you're looking for. Steve?
I was just going to, if I can, for 2 seconds, because I didn't manage to talk about it before, was just very quickly. Greg touched on the point that a super fund is a trust. There's also your family discretionary trust or whatever. Whether you've got individuals as trustees or a corporate trustee, part of that whole process is trying to work out the succession. If especially family discretionary trust, if you want to keep that going, and if you've got if it's individuals trying to either nominate in the deed itself or do it by will, who you're going to appoint as your successor as a trustee of that trust, or if it's a company, who you want to give that share to under your will, so that they keep control of that company afterwards, whether it's a sole director or whether you've got more than one. So that's the sort of things you've got to consider as well.
The complexities that need to be
so I just want to throw that in.
I'll hand back to Vince.
Thank you.
Yes.
Loving the questions. It's actually making the night much more engaging, and hopefully everyone is obviously getting something out of it. So we're going to spice things up a little bit, because it's a bit dry with some of the discussion. So we got Laura Salsbury from Generation Life. Now Laura will be talking about investment bonds and how that's a powerful solution in estate planning strategies. So Laura joined Gen Life in 2019 as a distribution manager and acting technical manager. She has extensive experience in the areas of Centrelink, aged care and retirement income streams, and has run her own aged care business many years ago. In the UK, she worked in the guaranteed investment bond and variable annuity space, and for many years as well as starting her career as a financial planner for the Royal Bank of Scotland in London. So welcome, Laura, to Shepparton and also for our building. And Laura's known her for a while. Throw any questions you like at her during the call.
Thank you, Vince. Thank you, everyone. Good evening, everyone. I believe I'm the last speaker of the day. Now, we've spoken a lot about estate planning, passing wealth on through superannuation, making sure your wills are tight, power of attorneys. What I'm going to talk to you about today is helping pass on your wealth with complete certainty, or investment bonds is what I'm going to talk to you about today, and it's about passing on wealth with certainty. So it's not about replacing a will, it's about an addition. It's an opportunity, and it will help you to effectively equalise your estate if you wish to do so. So as an example, if you've given a gift to one child and you want to make sure the other child gets something, you could structure an investment bond to pass to that child on your death, and it bypasses the estate. So the investment bond is a non-estate asset. Certainly you can structure it as a non-estate asset. Now, there are not many solutions out there that are non-estate assets. So what is an estate asset versus a non-estate? So an estate asset is something that flows through to your estate and through your will. It could be money in the bank, it could be investments that you own. And superannuation, you can have it passed to the estate, or you can structure it as a non-estate asset with a binding nomination. An investment bond is a non-estate asset if you structure it that way, and it can help pass your wealth on with certainty and privately. Now, why would you want to pass something on to someone and avoid the estate? Anyone have a guess? Why would you want to?
Benefit.
Tax. Yes, tax. That's a major one. Absolutely. Avoid tax consequences to the next generation and to your beneficiaries. What may be another reason why you might want to avoid some funds going through your estate?
Arguments.
Big one, yes, that's right, conflict. That's right. So we're going to talk about briefly where conflict can arise and certainly how you can help alleviate conflict. And that's where investment bonds can come in. So, Vince.
You want to explain why the investment bond doesn't form part of the estate?
Very much like superannuation, it has a binding nomination. So you can nominate beneficiaries and it can be anyone. So you can nominate charities, you could nominate a trust, individuals, a niece, nephew, a cousin, aunt, a neighbour, a best friend, a loved one, a love child, you know, so you can pass an investment bond on to anyone. And charities is a major one because 60% of charity bequests are challenged and 90% of family members win against those charities. So interestingly, if you want to leave money to a charity, just consider if you want to do it through your will or if you want to look at a non-estate asset and pass it on directly to the charity and bypass the estate. So that's what we're talking about here. It's an investment structure, so it's an investment-linked life policy. It's a tax-paid legal structure, which means that it's taxed internally. And by being taxed internally, you're not passing on the tax bill to the next generation. So it's taxed along the way, very similar to superannuation, but a key difference with an investment bond and superannuation is that there are no death taxes with an investment bond. No personal tax liability after 10 years as well. So you could own an investment bond for 10 years. You could pull the money out after 10 years with no tax consequences again. And you have access to, many asset classes, but Australian equities, global shares, etc. So you can invest in some assets that you want to, investments, but ultimately, again, one thing to mention is it is a financial product. And certainly it's something that perhaps would be good to get some financial advice before you set one up. What's happened here?
What sort of tax component is there prior to 10 years?
Great question. Paid internally. It may sound a little bit complex, but it's very simple. We provide a tax statement and you just take that down to your accountant and you pass it on, and effectively it's income from a life insurance policy, and that will then trigger a 30% tax offset. So if the gain was 10,000, the 30% offset would be 3,000, and you would get 3,000 off your tax bill, but you would need to declare the income from the investment bond within the 10 years. But after 10 years, there's nothing to declare. But also there's nothing to declare on death. So if you structured an investment bond to pass on death to your beneficiaries where it's tax paid and we pay it directly to your effectively beneficiaries' bank accounts, there's no tax consequences. So they receive the proceeds tax paid with nothing to declare.
We go through the maximum tax rate.
The maximum tax rate is 30%. So you have a range of funds, investments and managed funds that you can invest in. We have over 65. And ultimately, each fund can pay different levels of tax. So it's very much like superannuation, where the fund pays the tax. And effectively, it means that your beneficiaries don't pay the tax. And if you hold it for 10 years, there's no tax consequences as well. Okay, should we start again? Where are we at? Okay, so here we are. So what is an investment bond? It's a tax-paid structure like superannuation, but it's a non-super asset. Okay, so you can invest it with non-super money. Maximum tax rate of 30%. Investment bonds don't actually carry any distributions. There'd be nothing for you to report in your tax return. I'm not going to go into many of these today. We don't require a tax file number because, again, the managed funds pay tax internally. It is creditor protected under the Bankruptcy Act, which is a major tool. But ultimately, what I wanted to talk about is the use of the investment bond as a non-estate asset. In fact, we're the #1 provider of investment bonds in Australia, and over 55% of the inflows we receive are for estate planning purposes, where someone wants to leave money to someone privately, avoid the estate, and ensure that that individual gets that money effectively on your passing with no conflict and no tax consequences. So this is, again, something you would use alongside your will. And again, this is a non-estate asset or can be structured. So it's all about certainty and control. And you'll hear me talk about certainty and control quite a bit in this. But ultimately, I'd love to ask you a bit of a question. You're going to leave an inheritance. How many claims are brought by the immediate family? Then you talk about conflict, when conflict arises. And we'll talk about why conflict can arise. But anyone want to hazard a guess?
25%.
From the immediate family? So only 25% of claims from the immediate family?
85.
Any higher?
85.
85. Oh, that's extremely close.
95.
86% of claims are actually brought by the immediate family. And it can take over 12 months plus for a case to be heard in court. But it's not about the time frame and the costs involved. And Steve, you could probably share some of the ideas of costs that can be involved from an estate being challenged. It can be quite costly.
Look, depends how many parties involved, but if you get as far as a mediation before a trial, it's probably $10,000 per party on the day, plus costs up before then, so probably 20,000, 30,000 per party. And then if you go to court, depending how many parties, you know, same price again. So a normal estate matter could be $100,000 to $200,000 easily in court costs.
So what's a party?
Oh, as in how many
Challenges.
how many people were challenging? Yeah, how many different parties to the matter?
Yeah. So, sorry.
Could you put that in context though? Out of how many wills is there a challenge?
Oh, this is talking about any challenge. So out of any challenge of wills in Australia, 86% are brought by the immediate family of all challenges.
Yes, but we don't have a figure of wills and research being done of all wills, how many are challenged, to put that in context.
We don't. We just more about of all the challenges that have occurred in this. It's a research we have, but all challenges that have occurred, 86% are from the direct family. Absolutely.
So how do we make money on these bonds? Is it because we don't pay the 30% tax after 10 years, so it's returned us 3.3% a year?
So there's 65 funds, right? And we have a range of funds you can invest in, and all of the funds run different returns, right? It depends on whether you go into equities, Australian equities, international equities, and it depends on the market. So we are the structure, and that's what we offer. We offer the flexibility and the structure, but ultimately the investments comes down to the fund managers and the fund managers that you choose. But ultimately, as I keep saying, the best thing to do is to get definitely financial advice, certainly to make sure that you structure your investments correctly. You know, and also with an investment bond, there's many ways you can structure an investment bond. And I think that's key here to be aware of, is that you can structure it to pay out on death, tax-free, or you can actually structure it to transfer ownership. Now that's another one. You could have your investment bond transfer to the next generation. So your beneficiary inherits your investment bond. So if it's run 10 years, your next generation inherit an investment that they can draw tax-free income from. And they could pass it on to their next generation.
But we could potentially lose money in these bonds?
Well, it is investments. I mean, we have term deposit funds, got cash funds. So it depends on, again, it's down to your risk profile. I'm not here to give any personal advice because I don't know any of your circumstances. I'm just here as representative of Generation Life to tell you the type of structure we offer and how well it's suited for estate planning. I think one thing I wanted to go through today is a case study. And this is Tom, he's 75 years old. He has 3 children and 4 grandchildren between the ages of 10 and 15. Now, Tom wishes to provide 50,000 to each of the grandchildren when they reach 21 in age. His son, Sam, who doesn't have children, is not happy that his father is leaving an inheritance to his siblings' children. Sam has indicated he'll contest any bequest made to Tom's grandchildren and demand his 3rd share of the estate. So let's talk about, where do conflicts arise? An imbalance at an estate. How easy is it that there's an imbalance at an estate? Do you know that the balance between children and grandchildren is an imbalance in itself? So you might have 2 children or 3 children, 2 had kids and 1 didn't have children. That child that never had kids is potentially expecting a third of the estate. How are they going to feel about you leaving money to your grandkids or their siblings' kids? So even a balance between grandchildren and children can cause conflict. What happens when there's conflict? It can tear families apart. And that's something to consider. You know, think about your will and think about, is it equal? Is it going to cause conflict when your beneficiaries read the will? Now, what else can cause conflict? Leaving some money outside of the direct family. So if you wanted to leave money to a niece or nephew, or a cousin or an aunt, sister or brother, or a neighbour or best friend, or a charity, that can cause conflict amongst the kids. So again, if you want to leave something to someone outside the direct family, you know, consider whether doing it through your will and the estate is the right course of action, or whether to look at alternative structures. So let's go back to Tom. So he's concerned that his son Sam is going to contest the will and the estate. So this conflict could tear his relationship apart with his siblings, and he desperately wants his son to be part of his siblings' life. So he's worried that Sam will contest any bequests made through his estate, and the cost of the challenge could eat up into the estate's assets. So there's one solution here. One solution is you could set up some discretionary trusts. Discretionary trusts are non-estate assets, and you can structure them where your children are trustees, and effectively they will own the assets on behalf in the trust on behalf of the grandchildren. So you could have potentially 2 discretionary trusts here with the kids as trustees. That could be quite a costly exercise, but certainly something that can be structured. However, another option, and a much simpler option, would be to structure 4 investment bonds where Tom owns them, Tom manages them, and when Tom passes away, they will all transfer to respective children on his death. So each grandchild will inherit the investment bond and all the earnings. So it maybe is started at 50,000, but it might be worth, say, 80,000 now. And what you can do on top of that is you can actually set up a regular payment for the next generation. So if you've got a child who has, you know, is a bit hopeless with money, you could actually structure it to pay that child a monthly payment from the investment bond as well. So effectively restricting their access to the full amount. You can also add guardians onto these as well. So the guardian can own the investment bond, you know, when you pass away on behalf of the children. So there's lots of ways to structure them. And that's why, of course, it's very important to get advice, but just certainly have a think about your will, how you're structuring it, and certainly go and see Steve, right? Make sure that it's, you know, done well. But just to highlight here with Tom's outcomes, he was able to utilise the investment bonds to bypass the estate. The proceeds of his will will then be distributed amongst his children. So he's eliminated that conflict at the estate. He's avoided any tax consequences, including minor tax. Remember, think about minor tax for children under the age of, is it 18 or 16, where there's 18, could be minor tax consequences. But Tom, most importantly, is able to maintain family unity. And that's what it's all important about. So certainly consider when you're setting up your wills and ensure that there is an equalisation at your estate to avoid any potential conflict or any challenges. But ultimately, all I wanted to do is to just share with you some of the solutions available in the Australian market. And we are certainly our solutions available through financial advisors like Greg and the team here. But do you have any questions? Thank you very much. Oh, yes, we do.
I've got 2 questions. If you die after 10 years, I know you said death there's 0 tax. Does that still apply even if it hasn't been in there for 10 years?
Absolutely. So the death benefit payout can be at any time, even if the bond has been set up for a day. It still pay out on death tax-free.
My second question is, can you add them? And if you do, does that mean the 10 years starts from the anniversary of that addition?
Oh, that's a great question. That's a very great question. You can contribute to investment bond. In fact, many people do contribute regularly to an investment bond. Mums and dads set them up for their kids quite regularly, certainly to help their children get ahead. But you can contribute with a 25% escalation on your previous year. So if you put a 10,000 in one year, you can put 1,200 or 12,500 in the second year.
Adding to that 10 years.
Correct. So the 10-year always starts from the initial, and you can add to it as long as you stick within that 25% escalation as a cap on your contributions.
Is that 10 years? Does that start from the time you take your bond or from the time you put your last recontribution in?
When you start your bond, yes. So if you start it today, the 10 years starts from today. And that's really so that you can access funds tax-free, but you can access funds at any time. It's fully accessible. Many retirees set them up for estate planning and they set up a monthly withdrawal to fund their lifestyle.
With the bonds, you mentioned, you know, the strategy behind the estate planning. What other strategies, any different type of bonds?
Sure, saving for kids' future, that's widely used. Alternative to superannuation. So if you're, you know, it's mentioned actually, Greg spoke about removal of death taxes and recontribution strategies. We actually get a lot of recontribution strategies in the investment bond to remove those death taxes and eliminate those death taxes in the hands of the next generation. Centrelink, they can be friendly for Centrelink purposes. I won't go into that today, but they can be certainly very friendly for Centrelink purposes. And they can be held in trust environments because they don't carry distributions, so they can help reduce those distributions in the hands of those beneficiaries. But certainly, I think the core use we have over 55% is estate planning. Followed by saving for kids' future. So whether it's grandparents or parents setting them up for their children or grandchildren.
Another question.
Just really quickly then, so we put the money in, it obviously makes a whatever return, and then that profit is held within the fund but taxed internally at what, 30%?
A maximum 30%, that's right.
Yeah.
So if I to make one thing clear, the investments in these structures, the investment bond, similar investments that you can access through super. Yeah. So there's no different. You can access similar funds, if not they're identical.
Yeah.
So it's nothing spicy about it or unsolicited.
So just bear with me here. But so whereas super, like the profit paid may be taxed at say 50, it varies, but if we say around 50 or 15%, then like we'd be taxed the extra 15 on death. As opposed to 30% upfront. So it's
there are some
more about that eliminating the estate.
Depending on where the money's invested, you can reduce that tax rate from 30 to a lot lower. Yeah, it depends on where the money's invested. It can go as low as 12%. Yeah.
Obviously, it's I get that. Yeah.
I mean, superannuation is definitely the most tax effective solution in Australia. It's just that obviously some people may not want to put all their money in superannuation.
Well, some people can't because they've reached their cap. Yeah, that's a good alternative.
And I think it's important to understand, you know, at superannuation, you want to make sure you have a valid binding nomination. If you don't, then there's trustee discretion, which means that your wishes may not be met. While with this, it's a binding nomination and anyone can be a beneficiary.
Buy a bond, is there a commission paid somewhere along the line? Is it paid initially or is it paid annually?
No, oh gosh, it's a great question. There's no commission, absolutely not. I mean, obviously there's internal costs because you've got the fund manager fees, administration fee, but ultimately there's no commission involved in investment bonds.
But there's a cost to setting them up.
No cost of setting up, it's just an ongoing fee that's effectively the fee for the fund manager. So some fund managers have a fee as low as 10 basis points, some at 27, and then we just have our administration fee. But no, it's just like a platform, and you have the ongoing fees, but there's no setup fees or anything like that.
Last questions. Thank you, Laura, for your time and
thank you.
That concludes tonight. And again, thank you very much for making the time come out. And like I said earlier tonight, our main aim is to create some awareness around some potential estate planning issues that you may have, or tonight might be the first night we make the first step in getting your estate planning It feels it's ordered.
Thank you for watching this seminar. We hope you found it useful. Please get in touch with us if you have any questions.